Congress is empowered to pass immigration laws. That's what Congress has done from the beginning. And the executive branch job is to enforce it. Shortly thereafter, that being roughly a year or so later, the president reversed his position, and I believe by his direction, the Department of Homeland Security spit out a memorandum that created 4 classes of people. These 4 classes of people were then summarily exempted from the enforcement of immigration law, and 7 times in that memorandum they wrote the word on an individual basis, because they know that I'll just say by consent and agreement, the executive branch can't prosecute every federal violation. That's why they have prosecutorial discretion. And it's also a matter of case law out there, if you want to accept that term, and I generally don't. But that directive, I grant, the executive branch has to have prosecutorial discretion to determine how best to apply the enforcement and prosecution resources of the executive branch. They can't prosecute every single violation. But prosecutorial discretion only is on an individual basis. It's not on classes of people. But the president, Janet Napolitano, John Morton, created 4 classes of people and waived the enforcement of the law against those 4 classes of people. And now, to add insult to injury, these 4 classes of people that they decided they're not going to enforce the law against, the president created out of thin air a work permit so that they could work in the United States, presumably legally. It's an unconstitutional, lawless work permit that he has created out of thin air, but they are getting those work permits now to work in the United States because the president has crossed the constitutional line, that line between executive and legislative branch. Article 2 has gone to Article 1 and claimed authority. Now, when the Founding Fathers constructed this Constitution and they set up these 3 branches of government, often we're taught there are 3 equal branches. I'd argue that, no, the judicial branch was designed to be the weakest of the 3. But that point is not so important here, Mr. Speaker, but it's this: that this Congress passes the laws, the executive branch's job is to enforce the laws. The president has decided he can manufacture laws out of thin air and refuse to enforce the laws on classes of people that he's created by memorandum. That, as far as I know, has not happened with another president. There are about 5 places where he's crossed the line into the legislative branch. But our Founding Fathers envisioned this, that if you set up, and they did, they set up 3 branches of government, each with their own constitutional power and authority, each with their own domain. They knew that there were gray areas in between. You can never write something precisely so that it is a very thin, bright line. They did as good as could be done with the language that we have, and I applaud them for it, of course. But they envisioned that grayer line that couldn't quite be bright enough between the legislative and the executive, or the legislative and the judicial, that line in that triangle, for example, would always be defended by each side. They never imagined that the judicial branch would be able to claim so much authority over the executive or the legislative. They thought that the legislative branch would push back against the judicial branch of government, for example. In this Congress, I think, is not well enough informed on its constitutional Article 1 prerogatives. So when the Supreme Court grasps legislative authority out of that's granted in Article 1 to Congress, seldom do we stand up and claim it back again. And we're so numb to this that when the President of the United States, the executive branch, reaches into Article 1 and claims legislative authority, we can't get our back up in this Congress to put up a fight and tell the president that's an unconstitutional act, you've crossed a line, and we're going to pull this thing back and put you back in line and make you keep your oath of office. Now, that's the structure that we have today, and we have some tools that we can use, but we have to have the will. And Mr. Speaker, to bring this around to I'll call this a sub-conclusion of this discussion, when you look through a constitutional analysis and you look at the maximum authority that could be grabbed by the judicial branch or the executive branch or the legislative branch, what's the restraint on that? The Article 1 is really the strongest branch of government. The House of Representatives is reactive to the people. It's set up to be an election every 2 years so we can be reactive to the people. An example would be when people lost their good political judgment here in Congress and passed Obamacare in 2010. We saw a wave election and 87 new freshman Republicans came in. Every single one of them ran on the full repeal of Obamacare. Every single one of them voted, as did every Republican after that, to vote to repeal Obamacare. That's just the House reaction. The Senate didn't transform itself to that extent in the last election. Part of that was also the vision of the Founding Fathers. But they always saw that there would be a tension between the branches of government, that each branch of government would jealously protect its power, and that as that little tug-of-war went on, those lines would be defined over time and by history by people defending the authority within their respective branch of government. They did not imagine that the United States Congress would capitulate lawmaking to the President of the United States and not draw a bright line and not have a fight. And I am troubled by that, Mr. Speaker. And now we have a president who has manufactured his own immigration law, and now we have people in the United States Senate that are advocating that this Congress, because they declare that we have virtual amnesty in America today. It's not virtual, it's literal. The president created it. And I'm not suggesting that the previous presidents did a very good job of enforcing the law, but they didn't manufacture immigration law out of thin air. This one did. He created it. Now, the senators and members in this House also are advocating that there is de facto amnesty, and the only thing that we can do is conform the laws to the amnesty that the president has manufactured out of thin air. That's the same thing as conforming this Congress to an order by the Supreme Court. This Congress is the final answer on this. Whether it's a disagreement with the Supreme Court, whether it's a disagreement with the executive branch, the House and the Senate operating together, envisioned by our Founding Fathers, would be, we'll sort this out if we have to in the end, when there's a constitutional clash and a tug-of-war. That's sorted out by the people expressing their judgment in the ballot box. That's how you eventually resolve serious constitutional crises. So, we have a constitutional serious concern. I'm not to the point where I say it's a crisis at this point, but, Mr. Speaker, the president has conferred de facto amnesty. No, he's conferred literal, actual, factual amnesty. And now we have people that can't think through this constitutionally, so they declare we have to conform with the president's will, wish, or whim. And I suggest, no, we have a lot of ways to restrain the president, and I will not go into that today, but I do want to talk about how poor a decision it is to declare that all people in the United States illegally can stay here unless they commit a felony, or those 3 mysterious misdemeanors that can't be identified at this point, or that those that have been deported apply to come back in. If you're not guilty of a felony of some kind, we'll bring you back to America. That's the "we really didn't mean it" clause. And the third one is, all of those who are here after the deadline and who can get here after the deadline, never fear, because there is no one who has not committed a felony, nor not committed those 3 serious, mysterious misdemeanors, who is going to be subject to removal from the United States under this president or under the Gang of Eights bill. That's what we're dealing with. So, the rule of law, which is the core issue here, it is an essential pillar of American exceptionalism, is under assault by people in the Senate and in the House. And the President of the United States, obviously, who's blown a great big hole in it by his own executive actions. The rule of law. Now, all those people that are sitting around in the countries of the world that are inspired by the Statue of Liberty, that want to come here, many of them are subject to an arbitrary, no rule of law, where they can be stopped and frisked in the streets, and where the police can squeeze some dollars out of you just under the threat that you've got a speeding ticket, whether you were or whether you weren't. Not a place to defend yourself. They don't think they get justice in a lot of the courts in the world. They don't get justice in the streets. They don't have freedom of speech. They don't have freedom of religion. And they want to come here because we have, everyone is equal under the law. You remember the statue, Mr. Speaker, and it's tricky to say statue here as a member of Congress. Usually we say statute, but I'm talking about actually a statue of Lady Justice. and she's holding the scales of justice. And these scales are balanced. They're even. You see the pots hanging from the chains on either side. And generally when you see her, she's wearing a blindfold. Because we have equal justice under the law in the United States. The image of Lady Justice also attracts good people to come to America because they understand the image of the Statue of Liberty says, freedom, the lamp of liberty shining bright for all who will come here legally. And Lady Justice, blindfolded, equal justice under the law for everybody under the law here in the United States. But to waive the law and to give people a pass and to grant them a path to citizenship for what is their one virtue that they have? They have access under this thing to all of the welfare systems and benefits that we have in the United States of America today. Now I could do this little quiz test, and if it were fill in the blank, most members of Congress wouldn't get this right. There are more than 80 different means-tested federal welfare programs in the United States. More than 80. And 100 years ago, let's just say at the turn of the previous century, we were not a welfare state. When people came here to America and shuffled across the Great Hall at Ellis Island, where my grandmother did, and I know the exact date that she did that, I believe I've stood in the same spot where she did. When they came here, they had to show that they had a means to support themselves, that they were physically healthy enough to work, and able to, and they were checked in physically to see if they happened to be transmitters of contagious diseases at the time. And even though they were filtered and checked and sorted before they boarded the ship on the European side of this generally, when they arrived at Ellis Island, there still were 2% that didn't meet the evaluation, and they were sent back to their home country. Still, after the filter was put in place and they arrived here, 2% got put back on the boat and sent back again. Because we wanted to have a country then, we were a rational country then, we had an immigration policy that was designed to enhance the economic, social, and cultural well-being of the United States of America. What's wrong with that, Mr. Speaker? Every other country that I know of has a policy like that. I met with the Canadians yesterday, and I asked them, I said, could I emigrate to Canada? Could I meet the standard? You know, they were diplomats, so they didn't exactly say no, but I asked them a whole series of ways, and they absolutely could not say yes unless I married a Canadian. Now, I'm not likely to do that. I've been married for 40 years, and I'm real happy with the wife I have. By the way, I love living in the United States and having the opportunity to try to turn this country into an even better place. But here's the standard that they have. They give you points up there for, they want you to be young, they want you to have language skills, that means speak English, they want you to have some capital, some education, and some job skills, some earning capacity. Those are the criteria that they use in Canada. These are also similar to the criteria in the United Kingdom and in Australia. No one has the massive immigration, even as a percentage of their population that we have here. I've sat on the immigration committee for more than 10 years. I've gone to hearing after hearing. I've gone through reams of documents and reports and studies. Here's some of the under oath. If you're going to measure the merit of the applicants to legal immigration into the United States, and you score it according to the merits of the individual applicant, only between 7 and 11% of our legal immigrants are even scored on their ability to contribute to America. All of the rest of them are coming through on something that doesn't have anything to do with their ability to contribute to this society. 7 to 11% is all. So is it 89 to 93% of legal immigrants are going to come on something other than merit. Family reunification, asylum, visa lottery program, to give you a few. And that's legal, not counting the illegal, which is 40% visa overstays, 60% illegal border crossings. What kind of a country would turn its borders over to anybody that could cross them and turn over its legal immigration system to 89 to 93%, something other than some way of measuring how they contribute to this country?